Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Group of Downing Fry, and today we're joined with our host Jim York and his guest Donald Ross Jr., President and CEO of Ross Title and Escrow.
Thank you, Morgan, for the introduction. Well, Don, thanks for coming on the show.
Thanks for having me, Jim.
So the viewers that haven't heard of you, let's just tell them a little bit about yourself.
My name's Don Ross. I'm an attorney here in Naples. I've been practicing in Naples since '85, been practicing in general since '81, tax lawyer. Now I'm one of the owners of Downing Fry Realty, been the counsel for the company for over 30 years. Doing real estate closings for over 30 years. We have approximately 8 people at the office. It's tough to keep track. Most of them have been with me for decades. Good team, do our fair share of closings. Between those and the questions I have to answer at Downing Fry, we see a lot. We see quite a bit.
Yeah, we've been doing business for a long time together.
Since we were this tall, right?
Yep, since this tall. So, hey, let's get into the topic today. So I think we were talking, we've been talking for weeks about this. Coming on, for agents that want to expand their business, like in the state of Florida, that's just not in Collier County, they can help other clients in other areas, not just in Collier.
Sure.
So there is a contract called the FAR that they should be learning, and even the consumer or client should be familiar with it.
Absolutely.
So let's just talk about that.
I mean, I look at this as learning a second language. I mean, we are going through COVID. Well, hopefully it'll end sometime during my lifetime. Listings are low in Collier County. What do you do?
That's right.
I know what I've done. I mean, I've been doing for years. I've expanded my base of knowledge beyond NABOR to FAR. In part, I was forced on me, to be honest, because I'm the attorney for Downing Fry, so I get questions from agents in Lee County and Collier, so I learned through that. I learned through going through seminars in Orlando for the real estate certification. They teach the FAR contract there. So I know it's a statewide contract, and for years I'd be getting questions about, Don, if the listing says, only FAR only, do we have to submit it on FAR? And technically no, but my point back to the realtor who asked the question would be, if you learn FAR, you could eliminate that one obstacle between you and having a completed deal and just give them the form they want. I mean, you can work equally well with both contracts. Just because you're not familiar with one, don't let that stand in the way of you getting an offer in and getting it accepted. Now with COVID, it just accents it even more. Everything's sold essentially. We're down to about 1,200 listings approximately.
Yep.
And what do? I mean, you can get really good at listings. You can get, conversationally good with FAR. You don't have to be an expert. You can learn the basics, the basic differences between NABOR and FAR, and have somebody that you can call when you have questions. Now, with you and I mean, if you have a question or you're with a client on the weekend, you call me. I assume most realtors have somebody they call, I hope. I mean, you need somebody.
Well, I don't know if they do, but we've expanded our business. We've been going up to Sarasota, Bradenton, and worked our way down Punta Gorda, so we're familiar with that contract. But I don't know if everyone has the expertise in knowing the contract, or have somebody like yourself that they can depend on. And because a lot of these agents are, we've always tried to balance our business. Buyers and listings, where some people just like to work with buyers, or they like to work with listings. So it's so they got to be familiar. So let's go into some of the key points in the FAR contract that they should be looking at.
The FAR is statewide. It's 13 pages. They do time differently. Time is of the essence for everything in the FAR contract. So if you're late on a deposit, that's technically a breach of the contract. If you're late during an inspection time period, that's a breach. If you're late on giving notice of loan approval, that's a breach. It's not a breach, but certain things happen. So there's no wiggle room with time on FARBAR. With NABOR, time is of the essence for closing only. So, that fundamentally is a pretty big difference. The second big difference that I get a lot of questions on is deposits. People have buyers walking away from closings. They want to know what their rights are. Well, I always ask, is it NABOR or FARBAR?
Right.
Well, if it's NABOR and the buyer hasn't made a deposit, there's not a darn thing the seller can do. Zero. Because the sole remedy the seller has in NABOR is for deposits made. But if it's FARBAR, it's deposits made or agreed to be made. And that's on page 1 of the FARBAR contract. Some of the other differences, people leave out the washer and dryer in the FARBAR contract. It's not in the tangible property at the beginning of the contract. If you remember with NABOR, we have 13 lines at the beginning that list all the appliances and tangible property that go with the contract. In fact, with NABOR, you got to look at it closely and make sure you're not conveying something that the seller doesn't want to convey, like a home entertainment system or a security system. They might want to keep that. With FARBAR, you do the opposite. You got to add stuff in. You got to add a washer dryer because that's not listed. So the time, the deposit, adding in the washer and dryer, and then you get to inspections, and you got to realize that in FARBAR, mold and radon is not a general repair item. And in NABOR, we have a thing called defective inspection items, and everything's lumped into that category. With FARBAR, you have 3 categories, and it's in paragraphs 9 and 12, but you have general repair items, that's one category, and they have a default amount about 1.5% of the purchase price of the contract. Then they have wood destroying organisms, and that's 1.5%, and they have permits, that's 1.5%. So you got to know that general repair items does not include mold and radon. And if you're working with a FARBAR, my point to realtors out there is don't be afraid of the thing. It's 13 pages long.
Right.
Call somebody like myself. We have a form for mold and radon that you can attach to the FARBAR. I point out the issue with the deposit. I remind them to put the washer and dryer in. I give them guidance on the 3 categories: the general repair items, the wood destroying organisms, and the permits. And there's a definite strategy to this.
Right.
I do regular articles. Some of these categories, if you're making an offer, you might want to have the option to back out if the termites are too bad. Okay, so you might put a low number in. In that particular category, the seller does not have the opportunity to pay the excess over the agreed dollar amount. So you got to talk to your clients, and I'm happy to talk to people on stuff like this. But knowing how to fill out the 1.5%, the 1.5%, the 1.5%, whether you should put in a dollar figure, whether there's a certain strategy, if you're the seller or the buyer, call me. But don't be afraid of the contract. You want to know enough where you're conversational, but like learning any other language, you're not going to be fluent unless you speak it all the time, and none of us do.
Right.
So I'm always double checking, and I still do with NABOR, honestly. After 40 years, I'm still looking at NABOR because they're always making changes.
That's right, they are.
Or I'm looking at it from a different angle. A different set of facts. So you have to reanalyze it and see if you can make an argument on those set of facts. So filling out the FARBAR, I think, would be a wonderful thing. I'd say don't be afraid. You throw in the washer and dryer. You be aware of how deposits work. It's deposits made or agreed to be made that the seller can go after you for, versus NABOR, it's just deposits made. Have a strategy on general repair items, wood destroying organisms, and permits. If I were a buyer, I'd pick a big number for general repair items.
Right.
I'd have an addendum for mold and radon. And the form I have, I can tweak it so it includes allergenic molds. If I have somebody in my family that has a autoimmune disease, somebody might be allergic to a penicillin aspergillus that we have from the Everglades. Termites, I'd have a strategy of probably, if I'm the buyer, keeping the number down, because if the house needs to be tenanted, I don't know if I'd want it. I mean, you might
That's
disagree
right.
and you might
Right.
be okay with it being tenanted. Other people might not, but you know, the seller in that situation doesn't have the option of paying the excess. So you can discuss with your client, and if you don't know, just at least know that there is a strategy, and you know, we have a company attorney, or
Right.
I have an attorney, whether it's me or somebody else. Let's get them on the phone and plot strategy. So you fill that out. You don't just automatically let it go 1.5, 1.5, 1.5, because you could be giving away the farm and not realize it.
Exactly, right.
You know, or you could be obligating your buyer to buy the place when the termite damage is more extensive than they want, even if the seller's going to fix it. And they might be afraid that you're getting everything.
How about on using their own closing agent? How's that in that contract?
You select, that's paragraph 9, whether the seller selects and pays or the buyer selects and pays. And I have clients asking me, Don,
Explain seller, who pays what?
under the FAR contract, the seller pays for the documentary stamp tax on the deed, which is $7 per thousand, which is the same as FAR.
Right.
But then in paragraph 9, they have a provision where when they're negotiating back and forth on the price, you can put down who's paying title insurance, which is, you know, $5.75 per thousand. It's a smaller number than the documentary stamps on the deed. So in different counties, it's customary, like Lee County, for the seller to pay. But you know, indirectly, and you tell me if I'm wrong here, but when you have a listing and somebody makes an offer and you're analyzing, say, on the FAR, I would assume your owner would want to know, so what are my costs?
Exactly, they do.
You know, what's it going to, I mean, other than your commission, the
Right,
doc
yep.
stamps, what's it costing? And you point out the title insurance. Title insurance can indirectly, in that situation, depending upon the price, affect what amount purchase price
True.
the seller's willing to take.
Yep.
So, you know, in some instances, it, you know, the buyer ends up paying anyways,
Anyway.
and they're stuck using the seller's closing company. Other transactions, you know, I'll have clients, it's something bigger, something very expensive, and they want me to do more than just title work. They want me to analyze some of the exceptions to title, some of the restrictive covenants, things like that, or they plan to do expansions or additions, renovations. What do the documents allow? So in that situation, especially in expensive places, they want me to do the title work, even though they're the buyer, because they know I'm going to be doing extra work.
That's right, yeah.
And I can get access to the documents more readily that way. So on big deals, you know, the buyers tend to just want their own person to do the title, because that person's doing more than just title.
Yeah, and you know, years ago, you know, when we had the downturn, a lot of title companies went out of business, and you know, at least we know, you know, you've been around for a long time, and you know, you're not going anywhere. Your son's coming into the business at the end of the year, so.
Yep.
I know people were having troubles when they were reselling, that they went back to the old title company and, you know, didn't have the information that they needed, or they couldn't find a title policy.
Well, I mean, you know, I get asked, we've done this before.
Right.
I mean, do you use an attorney or a title company? Well, you can use a title company, but make sure they have an attorney that you can talk to.
Right.
I have one, I was asked yesterday on a deal that's closing on the 15th. It's $1.6 million. We represent the seller. There are 2 old permits. One's from like 1981 for a fence that's not even there anymore. And the other one is for something that we can't figure out what it is.
Right.
But it's from the 1990s. And the seller wanted me to talk to the buyer, who's represented by a title company that doesn't have a lawyer, and explain to that buyer permits. That this is not a big deal. It's not enforceable against the buyer. I mean, the county's not going to come out and give you a citation for a fence that's not there. Where's the violation? Plus, it's unenforceable under new statutes from 2019. But the title company doesn't know. So, you know, situations like that, using a title company without an attorney is not good. And it's a $1.6 million deal.
Right. Yeah, well, when I used to teach real estate, I used to tell the new agents that what they would do is do role models, like, fill out the contract yourself if it's your wife asking questions, or if you're part of a team or another agent, go back and forth. So the person's pumping them questions, and they sometimes learn faster that way than just,
That's a great
filling out
idea,
the
actually.
So,
I would have to be careful. I was polite when my wife was asking me that question.
and then if they were gonna,
You're not allowed to say it. That's a bad question.
Then the other thing I would do is, tell them if they were going to talk to you, or
Sure.
your client was going to talk to you, is highlight the areas on the contract so you're not bouncing all around. When you have you on your phone, that you can just go boom, 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 boom.
Well, I get it all the
highlights,
time,
so.
and they're from different parts of the
Right.
country, and if you have some vague idea of how they do it in New York or Illinois or Massachusetts or Georgia, which I do,
Right.
because I have family and who do closings in those areas, it helps
Yep.
because you can see it from their angle.
Exactly.
You know what they're used to, so you know how to explain it and put them at ease.
Yep.
A lot of it's putting them at ease, but the FAR bar thing tends to intimidate people because it's unknown,
That's
and we're all
right.
afraid of the unknown.
Yep.
And all I'm saying is it's not that scary.
Right.
You got to start somewhere, learn the basics. Time's different, deposit's different, mold and radon is not a general repair item. We can fix that. Don't lose your mind.
Right.
There is a strategy to 1.5%. You don't have to know it. We don't have to go over it in this show, but
Right.
there is one.
Yeah.
Call me,
Yeah.
or we can talk about it in the next show if you like. The financing clauses are different. Just know that they're different. The inspection time periods are different. FAR bar essentially has 2 inspection periods. The 15 days to do your inspections and give notice to the buyer. The buyer has 15 days to do the inspection and give notice to the seller. And then the seller has 10 days to give their estimates. And it normally ends there unless it goes over the dollar amount,
Right.
which we can get in later. But just know
Those keys.
we don't have
right.
the extra time that we have in NABOR, 15 days for inspection in NABOR and then 5 days to make your election. In FAR bar, it's all within the 15 days, and you give notice to the seller.
Right.
And then the seller has different rights depending upon whether it's a general repair item, would destroy an organism, or a permit. I mean, if it's a general repair item, they can go out and get another estimate,
Right.
which you don't do in NABOR. I mean,
Yep.
people do,
Yeah.
but it's specified in the contract in FAR bar. So just, you want to know that when you're filling out paragraph 9 for how much the seller has to fix, and that's a big difference. The seller has to fix things up to that dollar amount. Whereas NABOR, the seller can say, I'm not fixing anything. I'm not fixing a thing. And the only thing that the sellers would be liable in that situation would be things that happen after the contract's signed, under the maintenance clause.
Right.
So the things for a new agent who wants to make an offer in Lee County, they have a client who's interested in this $10 million house in Lee County. For crying out loud, don't argue about the form.
Right.
Use the
Form. And call you.
You work with whatever lawyer you work with, or use me.
Right.
I do closings in Miami. I do closings in Fort Lauderdale. I mean, I'm not running over there every day, but I have friends in those areas. St. Petersburg, it's the same darn contract.
Right.
So having some sort of conversational knowledge of it is good. And it not only helps you expand, but it helps you learn NABOR better.
That's right.
Because you're comparing it to something else. When you see that it contrasts with NABOR by not having mold and radon in there, you're more aware of the mold and radon being an issue in NABOR.
Yep.
And what is the issue? It's toxic and pathogenic mold, which we can always tweak. So there's a bazillion differences. But don't let it scare you. Learn the minimum. Have a lawyer. Call. Saturdays, Sundays are fine. expand.
Well, your information's on the bottom of the screen, and I appreciate you coming on the show today.
Oh, thanks for having
I
me.
hope we've helped a lot of people today.
Hopefully I didn't ramble too much, but
Well, just a little, but that's
just a little.
okay.
Typical. You could talk to my wife. Yeah, she'll tell you.
Thank you for watching our show today, and we'll talk to you and see you next week at the show with Don.
After the steroids wear off.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.